I have 11 pages of them. So if you think you're going to come in and ask me for any type of consideration on that plea, my suggestion is between now and when you come back, I don't have any more added to this.
Yes, ma'am.
I don't have to take the 15 years.
Yes, ma'am.
We could go to trial and you could get worse.
Yes, ma'am.
A jury will see all of this.
Yes, ma'am.
You're too old for this nonsense.
Yes, ma'am.
Before this hearing begins, here's what you need to know. This isn't a trial to determine guilt. The defendant has already pleaded guilty to aggravated assault with a deadly weapon. The only question left is his sentence. While the plea agreement caps his prison term at 15 years, Judge Raquel West can still decide anything up to that limit after reviewing the evidence. Listen closely to Judge Raquel West's questions. She's making sure the plea is voluntary and that the defendant understands he's giving up his right to a jury trial. But here's the real twist. Judge Raquel West won't base her decision on the crime alone. The defendant's behavior and attitude will also play a major role at sentencing. So if you were in his position, would you trust a judge or take your chances with a jury? Let us know in the comments.
Are you Luther Sharp?
Yes, ma'am.
Mr. Vasquez, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Sharp, in cause number 25, wait, are we going on count one?
Count one, Your Honor.
All right, hold on, let me get that done. Okay, in 25 DCCR 0916, the state has elected to proceed on count one only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon from May 26th of 2025, and how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Vasquez?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 15 years in prison, which means you're leaving your punishment up to me. And as long as I don't give you more than 15 years in prison, you can't appeal that. I can give you 15, I can give you less. It'll all be determined on the evidence and information that I receive at a sentencing hearing. You have an absolute right to have a jury come in and do two things. The first is to determine if you're guilty or not. And the second is, if they find you guilty, then you could leave your punishment up to them. If we go forward this way, you're waiving that right, and is that what you want to do?
This is one of the most significant moments of the hearing. By confirming that he wants to waive a jury trial, the defendant is surrendering one of the strongest constitutional protections available in the criminal justice system. From this point forward, there won't be a jury deciding guilt or punishment. Instead, the judge alone will determine the sentence as long as it stays within the negotiated 15-year cap. That's a strategic decision, and defendants often make it when they believe accepting responsibility could work in their favor. But it's also a gamble. The judge will carefully examine every piece of information before deciding the sentence, including factors that extend well beyond the crime itself. Do you think this was the right legal strategy, or would you have trusted a jury instead?
Also, part of that agreement is that the state would dismiss cause number 25. Y'all wrote C, but I think you meant DCCR.
That's correct, Judge.
DCCR 0917. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Sharp is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing, and so the probation department can do a pre-sentence report. We'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Vasquez, and he'll present it to me on your behalf when we come back. All right, you can go back with the bailiff.
Your Honor, can I speak?
Sure.
Would the court consider a bond reduction?
Not with the cap of 15 years in prison. No. You can go back to the bailiff.
That request for a bond reduction was denied almost immediately, and the judge didn't hesitate. From the court's perspective, someone who has already pleaded guilty to a serious violent felony and is facing a possible prison sentence presents a significant flight risk. Releasing the defendant before sentencing could undermine the judicial process, especially when the final punishment hasn't yet been decided. But what happens next is even more important than the denial itself. The judge shifts her focus away from the crime and toward the defendant's conduct while in custody. That's a reminder that sentencing isn't based solely on what happened on the day of the offense. A defendant's behavior after arrest can significantly influence how the court views their character, accountability, and likelihood of rehabilitation.
Mr. Sharp, I want to make sure that you understand and know that I receive, the district attorney's office receives, your attorney will receive all of your disciplinary incident reports from the jail. I have 11 pages of them. So if you think you're going to come in and ask me for any type of consideration on that plea, my suggestion is between now and when you come back, I don't have any more added to this.
Yes, ma'am.
I don't have to take the 15 years.
Yes, ma'am.
We could go to trial, you could get worse.
Yes, ma'am.
A jury will see all of this.
Yes, ma'am.
You're too old for this nonsense.
Yes, ma'am.
All right, go back with the bailiff.
The hearing ends with a clear warning from the judge. She reminds Mr. Sharp that she has reviewed 11 pages of jail disciplinary reports, and those records will play a role at sentencing. In other words, pleading guilty doesn't guarantee a lighter sentence. The court will also consider his behavior while in custody, along with the seriousness of the offense and whether he has shown genuine accountability. The final sentence will be decided at the upcoming sentencing hearing after all of those factors are carefully weighed. If you found this case as shocking as we did, make sure to like this video, share your thoughts in the comments, and subscribe to Zaini Says Courtroom Cases for more jaw-dropping courtroom breakdowns, real courtroom drama, and in-depth legal analysis.